This meeting is held to deal with basically just one item, which is an ESCOM application for a 6-year negotiated pricing agreement for Glencore. That's the only real substantive matter that's going to be discussed. So, members, with a show of hands, can I see if we can adopt the agenda as it is? Thank you, Madam Smanet. Thank you, Mr. Mkiza. Thank you, Madam Aseti. The other members, thank you, Madam Pongos and Madam Spear. An advocate, I saw you earlier. Thank you, Advocate Sitoli. Thank you, members, and thank you, Mr. Siband. Thank you, members. With that having been said, if we can then kindly complete the declaration of interest forms that have been published and return them to Madam Maswanganyi, who is assisting today. But I'm not sure if there's any member that may want to declare something verbally. I show of hands, members. None. I guess it's declaration of interest on the matter that is before us. Okay, with that, can I then hand over to Mr. Mavuso to present the application? Please respond to the question of whether there is an application or not. Please respond fully to that. Thanks. Mr. Mavuso and team.
Thanks, Chair. Chair, just to maybe give a summary.
Please hold before you do. Please. See a hand from Madam Simani. Please go ahead, ma'am.
Thank you very much, Chair. Good morning to you and good morning to colleagues. From my side, Chair, my concern is the time. We only have 40 minutes left for the hour that the meeting is scheduled for. And I think just like Mr. Sibanda, I also have a lot of questions. So given the fact that this is not the first time that we are having sight of the application, so to speak, would it not then be prudent that the application is taken as read? Then we are given an opportunity to raise our questions, because unless the introduction of the matter is going to be very brief and succinct, so that we've got ample time to ask questions. Thanks.
Thank you, Madam. That is your comment is very welcome. So, Mr. Mavuso, succinct to the point. Yeah, because this is not the first time he's serving here. Okay, please go ahead.
Well, I think from my side, what I'll do, I'll just maybe address the issue of the court decision. The court decision, Chair, is that NERSA has to make a decision and publish it on the 15th of December, which is tomorrow. So that is the main issue that we have to deliver in terms of the instruction that we get from the court. But I also want to mention that the issue emanated from a dispute in terms of who the supplier was. And from our side, we had mistakenly looked at the invoices in terms of who supplies the smelter, but the court has found it otherwise, that it is ESCOM. But I would like to give it to Bui to just also raise just the issue of whether we have the application or not. Thanks.
Good morning, Chairperson, members and colleagues. Chairperson, I'd just like to highlight upfront that figures are confidential for this application. Chairperson, we received an application for ESCOM for 5 of its Glencore smelters for a period of 6 years. 4 of those smelters are supplied by ESCOM, were processed and are completed. And according to the application, 1 smelter is supplied by the Rustenburg local municipality and was not processed, as it had some regulatory gaps that needed to be addressed, so that the processing is compliant with the framework. NERSA's understanding was that the application should therefore be made by the Rustenburg local municipality, as it has an agreement with the smelter, as well as it's responsible for the invoices invoicing of the smelter. However, the court has settled the issue and made a ruling that Eskom is actually the supplier because it owns the infrastructure. Hence, NERSA is then proceeding with this application. Chairperson, we had engagements with all parties separately, which is Eskom, Rustenburg Municipality, and Glencore, to try and find a solution to the issue of who the supplier is, but there was no amicable solution that could be found. In the midst of things, Glencore took NERSA, Eskom, and RLM to court, and court found in favor of Glencore. As Mr. Mamavuso has said, the NERSA was ordered to process the application and make a decision by 15 December. NERSA has also been made aware that RLM has filed an appeal to the judgment. And when a court order is made, it is binding, and an appeal then suspends the court order. But NERSA is processing the application because the parties, which is RLM and Glencore, have agreed to have the application filed by Eskom processed pending the court appeal process. Chairperson, figure 1 on page 24 of 72 proves.
Can we take it as read, and so that we can then respond to the questions from members rather? Would that be fine? Would that be okay with you? Madam, I'm just asking that. I know you're.
Yes.
Yeah. Okay.
That's fine, Chairperson.
Okay. All right. Thank you. So apologies to cut you. Members, again, as indicated, let's take the application as read. Let's deal with your questions. If we can then start by show of hands, members. Starting with yourself, Madam Simon.
Thank you very much, Chair, and thanks to the ELS team that have just presented. I'll just start, Chair, where she has ended. From my reading of the submission, I missed the point whereby there is or it didn't find audience. From what I've read, the fact that the decision to, despite the fact that the court decision has been appealed, we ought to be proceeding with the application. So I just didn't find it, or else I read over it. That's the first one. So for me, I was concerned that we are going to be presiding over a matter that is sub judice. That's the first one. The second one, what I would have loved to see is an external legal opinion that is going to give firm grounds in terms of our legislative framework on us being at the right side of the law by proceeding with an application that is not for somebody that is we are regulating. Because what to me became clear when I was reading the PEC was that the area is supplied by the Rustenburg local municipality, rather than Eskom. So then to me, that is throwing a spanner on the works in terms of our jurisdictions in presiding on the matter. That's the second part. The third part is that the matter is brought to us for approval, but my lean understanding is that a decision, it doesn't necessarily mean approval. We can decide that based on the circumstances around the matter, we allow an opportunity for the court processes to be concluded, because we do not know how long that is going to take. And my other concern is that should we decide to go ahead and approve the application, that might inevitably be used by one or other party in or against the other party's favor. So from my side, and I just didn't get any legal, besides the court order, I didn't get any reference to the acts that are giving us a mandate in terms of a firm stance or firm solid legal grounds that we would stand on to say that we are proceeding with this matter, despite now knowing that it's not and that is not an area that is supplied by Eskom. I'll pause there for now. Thanks, Chair.
Thank you, Madam Smane. Madam Spear.
Thank you, Chair. Chair, just a quick question. I think I asked it at the hearing. The issue of, I think the starting point for me, which Eskom confirmed, irrespective of the legal issues that are there with regards to the one, the Eskom representative confirmed that the contracting party, it's the municipality and the mine. They confirmed that. I heard that from Trevor Maybeck. So my question is to the team, because there is a issue that are also raised at the meeting, the issue that they would like to propose that the implementation be soon. The issue of the act, which is outside where the municipality needs to also undergo a 60-day process, which is Section 33 of the MFMA. What are the implications on this transaction then? Because for a municipality to enter into a contract of more than 3 years, it needs an MFMA approval. And in terms of MFMA, it needs to go to the process, which takes not less than 60 days, adverts and everything in terms of Section 33. I just wanted to hear from the team that have they taken that into account when they are approving this? What are the implications for us? Because they still need to go through that process. They wouldn't go without having the contract itself. Before they sign, it has to go through that process, and it also can be kicked out from those engagement processes. What are the impact of that from the decision we are going to make? Thank you, Chair.
Thank you, Madam Spear. Madam Pongwasa.
Thank you, Chairperson, and thanks to the team for the presentation, the overview. Chair, what I wanted to just clarify, my understanding is that the municipality, Rustenburg Local Municipality, is the licensee for the operation in Rustenburg. And then, however, there was a court ruling because there was disagreement between NESA and the operation that actually, who is the supplier? Is it Eskom? Or is it the Rustenburg Local Municipality? And there was a court ruling. So on the court ruling, I understand that it is said that there is an appeal. However, that particular application for appeal, did it expressly provide, for instance, that as for the court ruling to be, the judgment to be stayed pending the appeal? Because we can't just assume that it can be implemented, hence we are proceeding with considering the application. We do acknowledge that the court, I think, had ruled that Eskom is the owner of infrastructure, and thus it is the supply of electricity, even though that's done through the Rustenburg Local Municipality, which I would assume is the middleman or middle person or middle entity. So what are our intentions going forward? Do we know if we are proceeding within the correct, did we clarify all the issues? The technicality is to say that the appeal is silent on the staying of the judgment, hence we are proceeding with considering the application, or we haven't considered that. And then also, if you can just confirm that yes, the municipality is the licensee, but for some reason the court had ruled that as the infrastructure is owned by Eskom, then the supplier of electricity is indeed Eskom. Hence, we are proceeding to consider the application directly from Eskom. That one application that was outstanding. And also, does Rustenburg Local Municipality have a supply or service agreement with the operation? Or is that particular agreement directly with Eskom? Thanks, Chairperson.
Thank you, Madam Pongwasa. Mr. Mkiza.
Thanks, Chairperson. I have submitted my comments to the team, and hopefully when responding, you will touch on that. Suffice to state that some are flowing from what my colleagues have said. But in essence, I think it's important to first of all establish the legality. With ESCOM being now declared the supplier means they can enter into the NPA. But the question is with whom? And then if they enter to the NPA, let's say with the municipality, because my understanding was that there's still a negotiation taking place between the municipality and Glencom Merafe smelter. Can we go ahead and deal with this portion of the municipality and ESCOM? Then what about the other leg? But what will it mean? Just want to understand, when we're talking of an agreement, it's an agreement between who and who, and whether those parties must all be on the table. In other words, the agreements already dealt with before we can really say we're entertaining it. Because I note, for example, on 9.1.1, 9.11, sorry, we talk of an agreement in the context of Section 18.3, but it's not so clear what agreement. What does it imply to say you've got ESCOM as a supplier? Just for me that is a starting point. And then there are issues also that I've raised. For example, when the question was raised even during the public hearing as to whether there's agreement in terms of the benefit that accrues, because one would then also maybe there would be a need for one to consider that issue of the surcharge vis-a-vis the benefit that accrues, because you could have a surcharge that is actually less than what the benefit will accrue to the municipal area without the surcharge. But if you have the surcharge, then you don't have all those benefits being wiped out by simply looking at the municipality instead of looking at the municipal area. So just like those clarity provided. Thank you.
Thank you, Mr. Mkhize. Madam Assetti.
Thank you, Chairperson. Chairperson, I would like to start off with the team clarifying the extent of compliance of the application that is before us as we consider it today. The extent of its compliance with the framework for the NPA, the negotiated long-term framework for the negotiated pricing agreements. The extent of compliance with that is very important here, Chairperson, so that we can see the section that deals with joint applications and whether what is before us meets that requirement, first of all. And number two, who are the parties to the agreement? This question is important because the original application, as it was before us, it was processed and we would not have had the second bite. But now we have the second bite because the court says we must consider it. And so we know that even though the court says we must consider it, it does not mean that we should overlook the legal requirements of the document that guides us in processing this. And that document that guides us is the framework. And the framework talks about the agreements. Now, the other party, if we now say that the other party is part of the agreement, is a party to the agreement, that other party has not been heard. It has not been given a voice. So that borders on the fairness of the process. Now, we don't know whether that party still agrees to the terms of the very agreement that we are considering today. Because that party is the one that is taking the decision of the High Court to the appeal court, is taking that decision on appeal. So what are we saying about that other party, whether that other party is still
a party to the agreement. And the fact that that party has not been given an opportunity to state its case as we are processing this agreement. Now, is it an agreement when the other party is not a participant in this agreement? And how are you then going to implement that agreement? Or shall we just approve an agreement knowing that it will be very impractical to implement the agreement? We just do it anyway. We don't apply ourselves. We just do it simply because we want to process the application, because the court says we must process the application. The court did not say we must ignore the legal requirements. We must not follow a fair procedure in processing the application. The court also did not say that we should not apply our due diligence properly here in understanding whether what we want to see at the end of the day is going to happen. Because if the other party did not even participate in the processes, that could even be a serious problem for implementation. So we might well have a decision, but the implementation of the agreement, because the other party will say, we were not party to that agreement. So then it will be impossible or impractical. So that is the first thing. And therefore, the team must also clarify the issue of whether or not the joint agreement or the joint, application criteria, if I may use that word, has been complied with, which is in the framework. The framework allows for it. And also issues of practicality here for the implementation of the decision, than to just have a decision that is not feasible, a decision that cannot be implemented. And thirdly, the fairness of the process or the procedure itself. The last question that I have, Chairperson, is the compliance with other pieces of legislation. We know that when there's a need for these organs of state to cooperate with each other, especially with regards to matters of municipality, there are other pieces of legislation, one of them being the Municipal Structures Act of 1998. Now, we know that the ESCOM and the municipality would have talked about this. And if you look at the other court decisions, they always want the two organs of state to apply the cooperative governance mechanism that is provided in other pieces of legislation. One of these pieces of legislation is the one that I've just mentioned. So if now in this specific one, in this specific case, we don't hear from the municipality, because the supply of electricity will take place in the area of supply of the municipality, not in the area of supply of ESCOM. And so how this is going to work. And we must also be very clear here, because the team says it is ESCOM that supplies the municipality. But ESCOM clarified in the hearing that, as I put the question, it clarified that the invoicing to the customer is done by the municipality, because ESCOM cannot get into or go beyond the boundaries of ESCOM. So it is the municipality that then supplies. And there will be a contract between the municipality and the customer, and the municipality is not here. So how can we then say that no, all of the municipality part doesn't matter, because in any event, it is ESCOM that supplies? No. We asked about the ownership of the electrons, and we also asked who will then supply and who is going to invoice. ESCOM made it very clear that the municipality is the one that was invoicing, and it is the one that will still invoice, and the municipality will exercise its rights in terms of the distribution license, of which right empowers the municipality to supply or distribute electricity in that area. So, and that when this agreement is implemented, the municipality will be required So that is the legal aspect here. So why are we talking about just Eskom, and is Eskom that anyway owns the electrons and all of that, and the other one is a post box? I think that will be misleading, and also will rob us an opportunity to thoroughly look into some technical and legal aspects, and the fact that we will be undermining the rights of the municipality, of which rights we actually granted those rights by giving that municipality the license to supply electricity in that area. But again, we are the body that is going to then undermine those rights that we granted to the municipality. So I am concerned about that. And I'm also concerned about the fact that we're not talking about the Municipal Structures Act, and to what extent have we complied with it or considered it in the processing of this application? Same with the Municipal Systems Act, that also calls for a cooperative governance and some of these matters to be resolved. So those two pieces of legislation, to what extent have we considered them? Chairperson, those are the questions that I have. Thank you.
Thank you, Madam Massetti. Mr. Sibanda. But before letting you, Mr. Sibanda, I see Mr. Mkiza's hand is still up. Is it a lingering hand? Okay, please go ahead, Mr. Sibanda.
Thank you, Chairperson. Chair, I think there's a lot that has been asked around the legal issues surrounding the application. Perhaps mine really is to find out, so we are considering this application in the midst of an appeal. And I do understand that there is a court order that needs to be complied with. But when that order was issued, I assume that there was no appeal in place. That is in terms of the date by which we need to process the application. Now that there is an appeal in place, are we still bound by that order? There is an explanation in the submission in terms of the differences when an order suspends or rather gets suspended by an appeal and when it doesn't. But I'm still not certain, Chairperson, and perhaps I just need more clarity on that issue, so that at least we err on the side of caution, because proceeding knowing that there's an appeal in place and later on there's a different outcome, how are we going to unscramble the egg if we are required to, or if the judgment later on turns out to affect, to have implications for our decision. So it's just that issue for me that says, but we know there's an appeal in place, and yet we are proceeding. And does it mean that that judgment still binds us even if there's an appeal? Thanks, Chair.
Thank you, Mr. Sibanda. Advocate Sithole?
Sorry, I was struggling to unmute myself. Chairperson, thank you. Chair, having looked at the decision of the court, I just wanted to highlight one issue that I think maybe we may need to get input from the team if they haven't done it. Because normally, I think we all know that based on the Constitution, a municipality has got a right to supply within its area of jurisdiction. However, where a municipality is unable to do that, a municipality can get any other person or entity to come and supply within its area of jurisdiction. And I just wanted to just get an understanding from the team, because it's not coming out clearly in the submission as to whether has there been a discussion or a submission by the municipality, Rustenburg municipality, agreeing to give that portion of its area within its jurisdiction that Eskom could take it over and be able to supply the smelter, because we have issued a license to the municipality for its jurisdictional area. And if we are now going to be proceeding in the manner that maybe we are trying to, we may be seen to be contravening that particular process. And I think one of the processes to address that would have been that the two agree that the other will supply within its area of jurisdiction, and NERSA should amend the license accordingly. So I just wanted to find out from the team if there has been such a discussion, or have we had a submission like that coming from the RLM. Thanks, Chairperson.
Thank you, members. It's quite clear that the main issue here is actually a legal matter. Perhaps the analysis that we have on the document of the in the submission is not very clear on that front. So I'm going to ask that as we start, before requesting the other members of the team to respond, I'm going to ask Mr. Mrati to just explain the order, because the order had three parts, if I'm not mistaken. I just don't have the order in front of me. But that RLM is only appealing the surcharge part, is not appealing the NPA. But if Mr. Mrati can clarify that and clarify all of these legal issues, because it's quite clear that this matter is a legal issue. But I just want to raise just one issue, because I think for me this is how was captured. For me, the presentation by Miss Pagamile Hlubi-Majola kind of captured it all. That, you know, for them as the union to side with the employer is rare. It just indicates the dire situation that is facing that particular smelter. That at the end of it all, members, if as they've indicated, Glencore themselves indicated, this is the highest cost facility in their stable. That without an NPA, that smelter is not going to come back to production. So the surcharge that is sought by anybody, there won't be any surcharge if there is no consumption. So and the question is, as Ms. Majola said, Hlubi-Majola said, is that we've played our part. NERSA, we just request that you play your part. Whatever that we do, we need to play our part within the law. So that's why I think it's going to be important that we actually get Mr. Mrati to just talk to the legal, because most of the questions here are legal. Over to you, Mr. Mrati.
Thanks, Chairperson, and good morning to members and colleagues. Chair, maybe let me start from the provisions of the license that the regulator has issued to the municipality. The license has an exception that provides that in areas where within the Rustenburg municipality licensed area, it provides that customers being supplied by Eskom or any other licensed distributor at the commencement of this license are excluded from this license. This was a provision added in the license, recognizing that you have a contractual supply between a certain distributor and a customer within the licensed area of that distributor that has been licensed for the area. I wanted to start from that part, Chair. And coming then to this specific issue, what has been ventilated in court and in discussions that we have had with the municipality and Glencore and Eskom is that the smelter originally had two supplies. It had a supply from the municipality and a supply from Eskom. And the municipality notified Glencore of its termination of its supply from its substation to Glencore. And Glencore therefore remained only with the supply from Eskom, the technical side of it. But the recognition that existed at the time was that the total capacity of the smelter, the demand of the smelter, is incorporated into the NMD of the municipality. Hence, the municipality continued to be the billing agent of, or the billing person to the services that the technical supplies from ESCOM, the municipality billed the smelter. And when we had this situation, when we received the application, we wanted to understand that whether ESCOM is an agent of the municipality and the municipality remains a service authority. And we were made clear that there's no such an arrangement between the parties. They're just carrying out in terms of the arrangement that they have, but it is not in line with what our members, I think Madam Simane said, in the whole document, we didn't talk to the legal side of it or the citation of legislation. And I think it will also address I think it's Madam Sivia that raised it, that our section 28 of the Electricity Regulation Act details what.
Sorry, there's somebody.
Right.
I've been wondering, Mr. Mkhize Jr., please put your mic on. Kwelile Mkhize, please switch your mic off, please. Thank you. Please proceed, Mr. Mrat.
Thank you. That section 28 of the Electricity Regulation Act details what is it that is required of a municipality when it wants to have a service provider providing service within the municipality on behalf of the municipality. And Madam Sio was correct that it requires compliance with the Systems Act and the MFMA and the Electricity Regulation Act. We were made aware that neither of these legislations were considered in the arrangement that currently exists between ESCOM and RLM. And coming to the court judgment, and I will deal with the issue of us proceeding with the consideration of the application in the midst of an appeal that has been filed. Mr. Gumede had touched on the issue that the appeal is only on a limited basis. The appeal is not in the totality of the judgment. The municipality is appealing so the aspect that the municipality is prohibited from raising a surcharge to the smelter. That is the only particular issue that they are appealing. The order 1 and 2 of the judgment, they are not being appealed on. Hence, there was a settlement that has been reached between the municipality and Glencore to agree that the order 1 and 2 can be proceeded with for consideration, which the issue of the surcharge, once the appeal is finalized, the parties will engage in terms of how to deal with it, that if it has to be recovered from the time that the agreement has been entered in, has been approved, the NPA, that is what they will be implemented. If the municipality loses the appeal, the arrangement will continue as it is. So we are proceeding with the application with the agreement of the parties to the appeal, because we are not a participant to the appeal, between the parties to the appeal that have taken it to the judge to make it an order in terms of section 18 of the section 18.3 of the Superior Courts Act, which allows for an applicant to file an application for the implementation of the judgment whilst the appeal is proceeding, on the basis that if it has to wait for the finalization of the appeal, the applicant would suffer an irreparable harm in other than the respondent, whom the prejudice or the harm that can be suffered is curable post the finalization of the appeal. So that is the basis of us proceeding with the applicant. We're not doing it recklessly without an authority that has been that exists. The parties have agreed to that, they've agreed to that effect. Chair, I think the fundamentals of the licensing part have dealt with the issue of the service agreement between the municipality and ESCOM. Have dealt with it, that there is no such as from the communication from the parties, and the issue of the appeal by agreement between the parties anchored on the provisions of Section 18 of the Superior Courts Act, and also the issue of Madam Machete raising that are we continuing with this application within the correct frame. Chair, I can confirm that in terms of the interim framework, the provisions deals with the supplier of the evaluation of the supplier to the customer, the costs that are from the supplier to the customer that is necessitating the engagement of the negotiated pricing agreement, as also provided for in the policy position 14 of the electricity pricing policy. Chair, I would leave space for Madam Wisa to come in. Thanks, Chair.
Thank you, Mr. Murati. I think for me, okay, you've dealt with the issue of the framework, because I was going to see whether you've. I was going to pose a direct question that was asked by members. That is, this application. Do we have a valid application by the right people in line with the framework? Is that maybe that's what Madam Abinya can respond to. And with your assistance, Mr. Murati, do we have a valid application done by the right individuals who are parties to this agreement, and is it in line with the framework? Just that specific question, Madam Abi.
Thank you, Chairperson. Chairperson, yes, we do have a application before us. Though the application states that this is an NPA between RRM and ESCOM, the court has made a ruling that ESCOM is indeed the supplier of this smelter. Therefore, based on that, the NPA is between ESCOM and the smelter as the supplier of electricity for the smelter, and this is in line with the framework, because the court, as Mr. Murat has said, it has dismissed the surcharge portion of the municipality that the municipality wanted to charge. Therefore, this application from ESCOM is in compliance with the framework. Thank you, Chairperson.
Thank you, members. I think we need to be thoroughly convinced. I know that we are now right at 10:01, but there is no point in proceeding further without, if we can allow ourselves another, say, 15-30 minutes to actually make sure that we are fully aligned on this. But I think I recognize you, Mr. Mkhize. Can I just raise one issue? I think the challenge we are facing with here, colleagues, is that we've got a 1996 constitution that came into effect, and the 2006 Electricity Regulation Act that came into effect, and found existing agreements. So, for instance, some of these operations had been existing prior to the constitution, or prior to the promulgation of the Electricity Regulation Act. That the challenge with all of this is that, although constitutionally the right may belong to whoever, that in terms of our licensing, we then had to license areas which ordinarily would have been a municipal area. But that area is actually licensed to ESCOM, and we would have also licensed, even in particular licensed areas, we had particular customers that may have been supplied by a different supplier within a particular licensed area, and that we had to come up with a mechanism to exclude those for the continuation of businesses. That has caused us a lot of challenges, especially because with this particular one, I mean, we met with Glencore separately, we met with ESCOM separately, we met with RLM separately. And by the way, RLM chose not to participate in this public platform. They were not excluded. They just decided not to participate. And therefore, their right to participate were not in any way hindered with. They chose not to participate. But the point, though, is that in engaging with all of these parties individually before before this matter went to court, it became clear that this scrambled egg was very difficult to unscramble. But there was one fact. RLM is not supplying the smelter. Eskom is. Mr. Mkhize.
Thank you. I think that we need to be assisted by management in terms of the articulation here, clearly stating that the agreement in being the NPA, let me not just say, the NPA is between Glencore Merafe smelter and Eskom. Then that's what the court said by saying that Eskom is the supplier, means that the Eskom is the party that needs to contract directly to Glencore and Merafe. Then the question will be then the agreement with the municipality, just for my clarity now to understand. The negotiations with the municipality that the smelter talked about, is it just about the surcharge only? And that the agreement between Eskom and what then the agreement between Eskom and Rustenburg local municipality entails? Just want to get clarity there, because when during the public hearing, one would sometimes get it as if the smelter and Eskom, they are saying there must be an agreement between Eskom and the municipality, and then municipality and smelter. Just want to be very categorical in terms of who is being contracted, and what this negotiation then entails, so that you can start to understand whether we do really have an application that meets the minimum requirements, even in terms of the long-term NPA framework. Thank you.
Thank you, Mr. Mkhize. And I also like to apologize to Madam Maseti. I guess in starting to respond, I thought it was important that we respond at the global level, because it's quite clear that central to all of the questions was the question of legality. And even this issue that Mr. Mkhize wants to have real clarity on is actually a legal matter. But I'd like to request the team to then to go through each of the questions, yes, with the assistance of Mr. Mrati, to go through each of the questions one by one and actually respond to properly, assuming that we actually took notes. But before you do, Madam Maseti.
Thank you, Chairperson. Chairperson, I don't think the response provided by Ms. Mapinya is adequate, and I am not convinced, Chairperson. We must unpack and put the right context to perhaps the statement made by the court in the judgment that says that Eskom is a supplier. We must really clarify that, especially because the municipality RLM has not ceased to be a supplier in the Rustenburg area and in the area where the smelter is. It has not ceased to be the supplier. It still holds the right, and that is because the license is still valid. Why are we not dealing with that? Because cases where, especially the courts, when they look at cases where one has a license, it means that that person has been granted the rights to then exercise in line with that license. So why are we just throwing a statement that says that because of the surcharge, the court said, ESCOM is the supplier. ESCOM is not the supplier there. It is the municipality, it's the area of distribution or the area of supply of the municipality. So let us not, and the analysis must make that very clear, Chairperson. That's what it is, because the license is still valid. We as NERSA never amended the license, which is the point that Advocate Sithole raised, and we never also revoked that license from our side. It is still valid. So how do we then try and sort of harmonize this situation in our response when we put this, what the court said, and what we know from a legal point of view, given the license that we've granted? Why is it that we're not reconciling this situation properly, harmonize it properly, what this then mean? Rather than to simply go or simply state that the surcharge is not allowed because it is ESCOM, because the court refused to allow the surcharge, and therefore it is ESCOM that supplies the. It is not proper. Even ESCOM on record, under oath, ESCOM stated clearly, the representative of ESCOM, Mr. Mayvek, stated clearly that it never supplied directly to the municipality. It stated and provided clarification. It said, we have areas where we have a direct supply to the customer, and we have instances where we are not a direct supply to the customer. And this is one of the cases where we don't supply directly to the customer, and we never did, even before this application. It was always the municipality that supplies to the customer. We do everything through the municipality because they respect the legal status that the municipality is the supplier in that area. Why are we changing? Why are we not bringing that aspect in our analysis and then bring in that part that the court has stated? This, for me, is very problematic, Chairperson, and it needs to be properly clarified. Thank you.
Thank you, Madam Assetti. Again, team, you've had the questions from the top. If we can just respond to them one by one, but perhaps again, Mr. Murati, you can start with this, because from what I heard you say, and this is an issue of clarity, and this is what we thought we had ourselves ascertained, that in fact, this particular smelter is not supplied by RLM. It is supplied directly by ESCOM through ESCOM infrastructure, which unfortunately is ESCOM infrastructure that exists within an RLM licensed area. If we can just clarify that for me, that in fact this agreement is just an agreement between ESCOM and RLM, but it is not an agreement founded on who actually supplies the area. And also, if you can clarify the issue that I thought we had raised, that even in the license of RLM, this particular supply points were explicitly excluded, so that we can get clarity here on who in fact are the parties. Mr. Mrat, if we can start there, but team, please go back. Let's go through the questions one by one as they've been asked, so that all the members' questions can then be answered properly. But can I start with you, Mr. Murati? Just that clarification, please.
Thanks, Chairperson. I think the whole issue from paragraph 4 of the judgment, which has been taken out from the papers that were filed by the municipality and ESCOM, and Glencore, there has been an agreement in terms of the background of the supply to the smelter, that the smelter is physically supplied by ESCOM. But the issue of license, which the court has dealt with, to say, despite being the municipality the license holder, the issue that we're dealing with is about who is supplying. Hence, the court aligned with the submission by Glencore that because they are being supplied by ESCOM directly, the whole NPA should be between them and ESCOM, not with the municipality. But I also need to highlight, Chairperson, that in the midst of the application, I need to bring to the attention of the members that the municipality itself wrote to NERSA supporting the application that has been made by ESCOM. But the issue that still remained was the issue of the surcharge, that the court, in the reason why the municipality is taking up the judgment, the court dismissed that council resolution that dealt with the surcharge issue, that the municipality should be allowed to add a 6.1% surcharge in whatever the price that would have been agreed on between in the NPA. And in that letter, I think it was attached. The municipality also went into great length to explain the same issue that was reflected in the judgment, that the ESCOM is actually the physical supplier of the smelter and not the municipality. The municipality is retaining this because of being the holder of a license issued by the regulator to them. So, Chair, I think for me, the issues that has been raised in terms of, and you touched on it, that there are legacy issues that precede the existence of the ERA and the current constitution in this activity, because when you go through the papers that we have, it goes back to almost to the 80s and the 70s, this kind of arrangement that existed there with the changing of the company names taking place. But in terms of the exercise that as the regulator we are doing, we have satisfied ourselves that we have observed all the substantive issues. We have satisfied the procedural aspect of addressing this application by looking into the framework that has been issued by the department, looking at the EPP, looking at the ERA, looking at the court judgment, and our consideration. We felt that we have actually insulated the decision-making part of the regulator from any potential review that can arise out of the decision that the regulator can take. I will pause, Chairperson.
Thank you. By the way, as you, is it possible to actually have the judgment uploaded for the benefit of the members? Because the beauty with it is that it provides perhaps a better analysis that might not be coming out in our analysis. Please share the actual judgment if you can, please, for the benefit of the members. It also then so colleagues, can we then go back now to addressing these issues one by one? For instance, there was an issue raised by Mr. Mkhize on paragraph 911. It's quite clear that section is not the section in our Act or in the MSA. It's the Superior Courts Act. It's Rule 18.3. So sometimes we've kind of used terms interchangeably. So if you can maybe deal with each of the questions asked by members, please. Over to you, Mr. Mavuso and the team. Let's not just put pressure on Madam Mabinya here. Please assist.
Maybe I would just like to start from scratch, Chair, just to reiterate some of the issues. The first one, Chair, is to confirm that we have an application. And we also confirm, Chair, that the application is in compliance with the framework. And also, Chair, we want to state that when the court judgment was done, there was no appeal in place. Fourthly, Chair, we want to mention that the issue that Ms. Masetti did mention issues related to cooperative governance. And we want to state, Chair, that the municipality actually supported the application of ESCOM. And also the court, Chair, and in terms of our own way of seeing, we'll confirm that ESCOM is the supplier, but the municipality is the license holder. And I would like to call Bui to come in and to give some of the details. Thanks.
Thanks, Chairperson. Just to add, Chairperson, that because the court has declared ESCOM as the supplier, Our understanding is that the joint application then falls off because the court has excluded RLM from the NPA, because what RLM was wanting was the surcharge addition over and above the NPA. So the NPA then is between ESCOM and the smelter. I would also ask other team members to add chairperson to some of the responses that to some of the questions that the members have asked. Thanks.
Colleagues, we don't really have much time, so please just, and if you can combine questions, please assist. Thank you, Mrs. Chotlo.
Yeah, Chair, I think just one from my side, Chairperson. I think we have established, I think we have established and we have tried to convince members that the NPA or the supplier is ESCOM, and we have also tried to convince members that the NPA is valid in terms of the interim framework. I think the matter maybe that is the matter that is conflicted is actually the issue of the surcharge, which is exactly what you said, Chairperson, that the Rustenburg local municipality is actually the part that they are appealing, but the rest of the NPA is valid. And then our view is that we can continue, and then maybe go through the submission itself, and maybe members, if they can get into the details of the submission, so that we can get into the recommendations, and then we can then be able to take this to the ER this afternoon. Thanks, Chair.
Thank you. Okay, I see I'm struggling to get, Madam Maseti, I'm struggling to get the team to go through each question one by one, but I'm hoping that the overall analysis will assist in terms of our responses. But before I conclude, Mr. Murati?
Chair, I just wanted to give this last part regarding the agreement, that from our understanding that when we process it, we're processing an application for an NPA between ESCOM and Glencore. And the municipality has submitted to us confirming that the agreement will be between ESCOM and Glencore, but the same agreement that will be there will be replicated between Rustenburg municipality and Glencore in terms of the same code of the same conditions applicable to the NPA. So the municipality has also confirmed that they will recognize the NPA that is between ESCOM and Glencore. They will replicate it in line with the license that they have over the area. So the right of the municipality is not being taken away in terms of being the licensee of the area.
Thank you, Mr. Murati. Members, I think for me, as I've been listening to all of this, okay, before I conclude, Mr. Mkhize.
Thanks. I appreciate what Mr. Murati has put forward now. I think because when we're saying that ESCOM is the supplier, it means it's the one that the court says must be contracting with Glencore Smelter, which then is the application that we're dealing with. Then clarity must also be provided in terms of the other agreements as to what then they will entail. Because even Glencore Smelter was stating that they're going to have negotiations with the RLM, which is the Rustenburg local municipality, which then must be clearly articulated here, so that we know exactly what we are doing with. Because the way it is written is kind of convoluted. One doesn't seem to understand. And two, that the judgment is not stayed in view of what the appeal entails. That also to be able to enhance those. That for me, then I think will assist in terms of really understanding the legal basis and clarity in terms of what are we dealing with. The other matters still need clarification, but for me, that is a key thing to say, what are we really dealing with and how legal it is, understanding that the court has already made a ruling in this regard. Thank you.
Thank you, Mr. Mkhize. Members, I'm just trying. I'm cognizant of the time. It's 10:25. Madam Assetti.
I'm sorry, Chairperson. Chairperson, I thought that they will also respond to the questions that I asked. A question about the extent to which we've considered other pieces of legislation apart from the PFMA and the extent of analyzing the critical issue in the assessment, the critical issue raised by Mrs. Bia, first of all, because all of those legal implications must be analyzed properly and our position be articulated properly in the analysis. So that's the first one insofar as the PFMA is concerned. I specifically then asked about other pieces of legislation, one of which is the Municipal Systems Act. I asked a question about that, and I also asked a question regarding another piece of legislation, which is the Municipal Structures Act of 1998, and nobody answered that question, and it's very frustrating because we do want to get to be actually comfortable by the time we take a decision. That question has not been answered, Chairperson. And the other question that has not been answered, Chairperson, and I'm putting this on record, is the is my question pertaining to the fairness of the process. Yes, I heard you, Chairperson, when you said the municipality was informed, but it did not participate. And I just want to also indicate the requirements of the compulsory consultation stated in Section 10 of all the 4 pieces of legislation that will regulate the ERA as well as the National Energy Regulator Act. So Section 10 is very clear that every decision that is taken by the energy regulator must actually consult the affected parties, and that is aligned to PAIA as well. So that also, Chairperson, has not been responded to, so that at least we're comfortable that we are going to make a decision that is legally sound and justified to the extent that we are concerned about this. And the other thing, Chairperson, which is the last point for me, it is important, and it is the constitutional requirement that when stakeholders appear before us and make input, that their input be understood accurately and their input be carefully considered and analyzed. Now, I'm mentioning, for instance, also the point made by Eskom under oath, where Eskom indicated that there will be a role by the municipality if Eskom were to effect the supply of this. So if now we take a decision, what is going to happen there, Chairperson? And Eskom did make mention of the joint agreement or joint application. And I asked the question for the first round about the joint application, and that has also not been clarified. I would like to stop there, Chairperson, but I'm recording just those issues that were not responded to. Thank you.
Thank you, Madam Assetti. Mr. Mrati, would you like to venture into answering those unanswered questions first before I take this matter for a conclusion?
Thanks, Chairperson. I think let me touch on the issue of probably just an overarching statement that the only part that we are having in this situation, in this application, is the settlement on the tariff that will be applicable to Glencore. In terms of all the other activities, they are going to remain the way that they were before an NPA application is brought to the regulator. I'm saying this in the context that the relationship between Glencore and Eskom has been in existence, and the relationship between Glencore, the municipality, and Eskom has been in existence for quite a long time to date. The only difference was that the regulator was approving the tariff applicable to Glencore in the hands of the municipality. So what is being changed is now there will be an NPA that would be inexistent, overriding the submission of an application for a tariff by the municipality to the regulator. That is the only thing that will be changing. The rest of the activities is going to remain the way that they were, with Eskom doing the technical part of it, the physical supply to the smelter, and the municipality doing the billing part of it. I will have to look into the applicability of the Structures Act, Chairperson. What I understand is the applicability of the Systems Act that deals with in Section 75, that deals with the imported part that is found in Section 28 of the Electricity Regulation Act. Hence, the referencing of the Systems Act and the Municipal Finance Management Act by that when the municipality chooses to have a service provider, they will have to carry out that part. And I touched on it earlier on, Chairperson, that we made this direct inquiry to the municipality. Are they having a service agreement with Eskom? And the municipality denied that they don't have a service provider agreement with Eskom. They just have that set up in a manner that it has been continuing in that format. So, Chair, I hope I've provided clarity in terms of what fundamentally this application deals with only in the limited nature that it is, that it doesn't affect all the other aspects that have been inexistent. Thank you, Chairperson.
Thank you. Thank you, Mr. Murat. Members, I'd like to maybe just try to summarize the issues from where I'm sitting, and then hopefully then we'll be able to then go towards making a decision. I think for me, the first issue is that it's quite clear that what's concerning here, the key issue here is the quality of the analysis. So if, for instance, the analysis that is provided in the documents that we have, for instance, at least covered where there was firstly a proper legal analysis in terms of our law, in terms of all of the issues like the license holder, who we've granted a license to, and even perhaps supporting evidence being supplied to indicate, for instance, if there is a thing that says, although this RLM is licensed to supply here, but there are these exclusions. But we can actually point to those exclusions directly in the documents that sits before us. So, number one. Number two, even in terms of the framework, that then says the reason why in the first place this was not considered in the first round when the other four were considered, the other four NPAs were considered, is because at that time the view was that this application was not complying with the framework. But subsequent to that, there was an analysis, and that perhaps even if our analysis failed us, but at least the court papers and the summary from the court papers was clear enough to indicate that who actually is the supplier here. And it's quite clear that the supplier is Eskom. The private agreements that they may have between RLM and Eskom, those are private agreements. They do not affect the actual framework. At least that's what the courts actually were trying to allude to. That I think in the analysis, it would have been useful that we had done this proper analysis. Perhaps that and it's clear in the sections that we are now analyzing our law and all of the laws applicable. Secondly, we are now analyzing the framework. And then thirdly, for us to have analyzed what the courts actually said. Now, the court judgment, because if we had actually perhaps done that properly, maybe this would not have arisen. The confusion is because, for instance, if the issue is that the smelter is contracted or is supplied by RLM, then all of the questions which were asked, questions specifically asked by Madam Spear, then applies. But if it is not, then that question does not arise. So that is the for me, I think central in all of this, it's the quality of the analysis, which has been something that we've been trying to actually get round to getting ourselves all geared up to be able to do this analysis properly, because these documents become discoverable documents and they speak for us before courts when we are not there. So that's the one part. And I think, members, I apologize for that. It's something that we as a team, collectively, we need to start working on to better analyze any application that comes before us. But I think for me, the key issue here is one which is comes out of the Constitution, section 229 of the Constitution, that is the right of the municipalities, that is, which is the right of the municipality, that is enshrined in the Constitution, to be able to levy a surcharge for services or on services provided by itself or on behalf of the municipality. This is a constitutional issue. I do believe that this appeal will probably go all the way up to the Constitution, because that question has really not been answered. That says, to the extent to which the municipality has a right to levy, to put a levy on electricity or on services, or particular electricity that is supplied by Eskom, even in an Eskom licensed area, because even if it's a licensed area in terms of the era, but that area may most likely exist within a municipal boundaries. The question is, do municipalities have right to levy a surcharge on that? That's a constitutional question that needs to be answered. Now, unfortunately, that question is separate from the NPA. It is not something that we don't regulate surcharges. Whatever taxes that are imposed, they are just a pass-through. So for me, I'm just like to say, I think we need to actually look at this problem, this issue in that light. That in this particular case, it's quite clear. And I know Mr. Marburg kind of ducked the question of who owns the electrons, and he used an example, and hence the issue that was raised by Mr. Mkhize earlier in terms of taking exactly what was said by Mr. Marburg and correctly capturing it is important. But the point is, for me, colleagues, is that I don't know whether we've managed to convince members that firstly we have a valid application, and this agreement is between Eskom and RLM. All of the other agreements, as requested by Mr. Mkhize, between RLM and Eskom, the NPA is between the smelter and Eskom, who's the supplier of electricity, and all of the other agreements that that might exist between Eskom and RLM. Those are private agreements. We still need to have sight of them, but I do not believe that members that they should affect us making a decision today. So I'm just trying to guide members, but I'm really hoping that, although perhaps the analysis did not on its own reveal this, but the conversations that have since ensued have basically revealed this. And mine would be to then say we need to update the RFT to include this analysis that has come out at this stage, update the RFD accordingly, such that it captures the essence of what was revealed today. So that's going to be my request, members, and I'd really like us to take you to the decision that is sought, and seeing whether the members of the ELS, whether you believe that you've been sufficiently responded to and convinced of the validity of the application, and that application is made by the right parties, and that we are quite clear that the NPA is between the smelter and Eskom, and that we can recommend that to ER this afternoon. So, members, that's how I would like to actually summarize this. Not taking away all of the issues that you've raised, they still need to be dealt with, and the RFD should better reflect that. So, members, with that, if you don't mind, I'm hoping that we have sufficiently dealt with this matter, so that I can then take you to the decision that is sought, which is on paragraph 14. I know it's meant to be 14.1 and 14.2, which is 14.1 is that the Eskom's application for the 6-year NPA for Glencore Merafe from Venture Ferrochrome Smelter, that be approved, and also the draft decisions. I guess we may then say the draft decisions the draft is that the reasons for decision document needs to be updated sufficiently to cover all of the issues that were raised by members. I'm not sure, members, by show of hands, whether we will be comfortable to actually recommend this. By show of hands, members. Thanks, Madam Aseti. Thank you. Thank you. I think it's all the members. Madam Smane and Mr. Sibanda. Thank you, Mr. Sibanda.
Oh, I thought it's for the ELS members, Chair.
I see. Okay, I'm always confused when it comes to this extended, whether non-ELS members can vote. But okay, maybe let's just leave it to just the ELS members. Mr. Chokwe, please guide.
Sorry, Chairperson, I was struggling to unmute. Ms. Mann is right, Chairperson. Whilst it's an extended ELS, it's still not ER. Therefore, members of the ELS are the ones who must actually recommend or approve. Thanks, Chair.
Thank you, Mr. Chokwe. So, okay, let's start again. So if we can then ask the members of the ELS if they are comfortable to actually recommend this NPA, but that the RFT itself needs a bit of work. Madam Aseti, Madam Spear, Mr. Mkhize, advocates it all. I also support. So you've got 5 out of 5 from the ELS. Thank you, members. I know this has taken a long time.
Chairperson?
Yes, Madam Aseti.
Chairperson, I think for the purposes of these back-to-back meetings to the ER, it's very important that the summary of the deliberations, especially the issues that we agreed upon, because we struggled to get to a decision. So it's important that we put a summary properly when we get to the ER as to what the basis of our decision is based on the enhancement of the analysis, especially the legalities, the legal requirements, so that all of those things are clarified upfront, Chairperson. And also it must be dealt with the issue of then the implementation of our decision. Or the risk of implementing our decision at the area of supply that is currently with the municipality, if the municipality is not in support. I think that becomes very important, and it's something that even in the hearing it was dealt with. Thank you, Chair.
Thank you, Madam Aseti. Unfortunately, I'm not sure. I'll try. Because this is now going to have to, I'll have to present this, because unfortunately, I'm not sure in terms of the timing, if I can be assisted from RSU. We're supposed to start with the with ER at 11, correct?
Yes, Chairperson.
So I think because now it just leaves us 15 minutes for that summary to be done, but the colleagues will need to do that. We haven't signed a 2-pager on this one yet, because we needed to wait for the issues that are raised by members. But so that we don't do a injustice to the 2-pager and the summary and present things that were not said, it would be useful, I think, that the team's given time to listen to the recording and actually to summarize this properly. However, I will try to summarize as much as possible. Oh, sorry, we're still live. Christ, apologies. I'm discussing internal matters on a live platform. Can I then request that we actually just ask Mr. Mateja to then stop the live streaming so we can discuss the internal governance matters on this. Thank you. And apologies, members. We've been debating this for such a long time.